So you can continue eating your lunch through this exciting event. Welcome to this very special event for the Law and Economics program. We've assembled what I think are the Regulatory Oversight All-Star team. And I'm delighted that the moderator for our panel is going to be Dean Rubin. And it's especially pertinent not only because he does work in administrative law, but because of his leadership role at the law school in support of academic conferences such as this, which wouldn't have happened if he had not been dean. The general format's going to be, after his introduction, each person's going to talk for about 10 minutes, then there's going to be panel discussion.
Thank you, Kip. And I want to just point out, you probably know, but this is a unique program that we have in the law school. We're the only law school in the United States that, in addition to awarding a JD and an LLM, also awards a PhD in economics. And Kip, along with Joni Hirsch, have been instrumental in creating that program and bringing a wonderful and sophisticated interdisciplinary element into the law school. And of course, it's just indicative, as is this panel, of the enormous overlap of these two fields that's occurred over the course of the last 30 years, and indeed is one of the most significant events, at least in the intellectual history of law, and I hope at least a notable one in the intellectual history of economics as well. As Kip mentioned, this is a wonderful panel. I'll introduce the speakers briefly, and then they'll speak in the order I mentioned them. I should also add, this is particularly exciting for me, we have a new course here that's part of our curricular innovations called the Regulatory State, which we teach to first-year students very often in the first semester. And one of the things we tell them is, in addition to that there being something called the common law, there's something called regulation, and that central to regulation is something called OMB and OIRA. And this is an X-rated course because we tell them about things like OIRA and cost-benefit analysis right in their first semester of law school. And so that's an innovation for us, but also exciting for me to actually meet the people I've been reading about and teaching about and whose work I've been studying. In order of speech, our speakers are Susan Dudley, and Susan was the OIRA administrator from 2007 to 2009. She was formerly the director of Regulatory Studies program at the Mercatus Center at George Mason University, and was before that a vice president of a consulting group in Washington, D.C., and has written extensively in this field. John Morrall has been involved with OMB and its cost-benefit efforts since their inception. He was an economist at OMB and also in the White House Council on Wage and Price Stability, and was the branch chief for health, transportation, and general government at OIRA. And his work on the calculating the value of life is well known to everybody in the field. And John Graham was the OIRA administrator from 2001 to 2006. He's currently the Dean of Public and Environmental of the Indiana University School of Public and Environmental Affairs, and was formerly the president of the Society for Risk Analysis. So we have three people who have been absolutely instrumental in the process that we're going to be discussing, and it's an extraordinary opportunity, I think, for all of us to hear from them. So without further ado, let me start with Susan. Each person, as Kip indicated, will speak for about 10 minutes.
Okay, so I guess I don't have to start this, since you've all taken at least the introductory course in the regulatory state. I don't have to start by convincing you that the government should be valuing lives. Is that true? We don't need any, why the government is doing something as crass as valuing something that is naturally priceless. So I'll just plunge in. I was administrator from April 2007 to January 20th, 2009. And during that window, OIRA reviewed and agencies issued 105 economically significant regulations. Now, economically significant means it's expected to have impacts of at least $100 million, either the costs or the benefits. So those were the biggest ones. And those are the ones that agencies generally conduct a benefit cost analysis for. So when Kip asked me to speak at this panel, I thought I would look at them and just see how have lives been valued in those. Well, as it turns out, only about 14 of those 105 regulations, only for about 14 did agencies actually calculate a value of a statistical life and use it in the analysis. And of those 14, as far as I can tell, and I just did a rough look last week, only one might the value that we used have had an effect on what the final decision was. And that was a Department of Transportation vehicle regulation that looked at the whether side impact airbags made sense. And a DOT in that rule used a value of statistical life of 3.6 million. And perhaps if they'd used a higher value, they might have chosen a different standard by which to measure the impact or something. So that's the only one. Others, there was one where it was calculated but not considered because Congress doesn't allow EPA to consider economic trade-offs under certain Clean Air Act regulations. So there was one rule where it was calculated, but the administrator of EPA had to make his decision without looking at that information. For the others, they considered it, but it wasn't pivotal. So EPA, more on the Department of Transportation, even the Department of Homeland Security did calculate value of statistical life, but the benefits exceeded the costs in these regulations by such a large magnitude that even if we had used a statistical life saved value of 2 or 6 times higher than what they used, it wouldn't have changed the decision. So what were the rest of these? There were others. There was another category of rules where the objective was life-saving, and at least the agencies hinted at some life-saving potential from the rules. But they didn't quantify it. An example of that would be trying to protect the beef supply from mad cow disease. And in that, the agency, this was the Food and Drug Administration, they were able to estimate, they said that if we require certain procedures, there's a 99% reduction in risk associated with VSE. But the fact of the matter is there haven't been any cases of an illness, someone coming, it's Creutzfeldt-Jakob disease. We haven't had a case of that in the US. So a 99% reduction from what may be close to zero, they were not able to calculate it. Similarly for Homeland Security. The Homeland Security Department recognizes that part of their objective is saving lives, and yet it's very hard to do in a quantitative way. And they do rely on break-even analysis, and sometimes in that break-even analysis, they do incorporate value of statistical life, but other times they don't. But the vast majority of those over 100 regulations were actually aimed at something other than life-saving benefits. Regulations aimed at increased fuel economy or energy efficiency from appliances, endangered species, protection of right whales or polar bears from endangered species, Medicaid and Medicare regulations, which employee benefits information, Family Medical Leave Act regulations, air traffic congestion, homeowner initiatives, especially towards the end. We had a lot of financial and homeowner-related regulations. And yet, when we tally the estimates of benefits and costs of the regulations for the government, if we look over the past 10 years and tally them up, which OMB does do every year, the benefits are dominated by benefits from life-saving interventions. And as the two people at this table, as well as the professors that you have here, have done path-breaking work, it really does matter that if we could focus our regulatory activities on those that have the greater life-saving benefits, you could double the life-saving benefits. This is John's work. You could double the life-saving benefits or reduce the cost of achieving those benefits in half. So it is important. Back again to the benefit and cost figures. As it turns out, those benefits that are dominated by life-saving benefits are actually dominated by one single pollutant, reductions in particulate matter. So that pollutant in particular accounts for from between 60 and 90% of the total estimated benefits of all government regulation. That's over $500 billion a year. And this brings me to my two observations. And is there anybody going to tell me when I'm running out of time? Kip doesn't have his bell here to...
I'm the bell.
Will you give me a 2-minute warning? All right. Two observations on this. First, we have a tendency to talk about life-saving as if we're saving lives, but we never permanently save a life. We're all going to die eventually. So I think it's important to think in terms of how many years of life are we saving? Are we extending lives? That's what our policy goals should be finding ways to help people live longer. Now, that seems rather common sense to me, but in my confirmation hearing, it proved to be rather controversial. I know the two people at this table have run into a lot of criticism for that. That's the senior death discount, cleverly named, that if you advocate for looking at whether something extends lives, then you're denying seniors life-saving interventions. And the current nominee as well seems to be facing problems for that same issue. So that was my one point. The second is an observation that we see a difference between the way we value safety and health benefits. Safety benefits, those from the Department of Transportation that deal with accidents in cars. First of all, we have actual data, actuarial data in advance that helps us helps us make our estimates. And second, after the fact, we can look to see whether we were right. And NHTSA does that periodically. It looks back to see whether the life-saving projections it made actually turned out to be true. Whereas on the environmental or the health side, we're rarely able retrospectively to determine whether the estimates we made were right or not, because the benefits tend to be in the noise. So when we talk about these huge benefits, for example, all right, I'm almost done, this is good. And that's a question, actually, I will just leave for the panel. Why is that we seem to be willing to spend more on the more uncertain health benefits that are further into the future and we're less sure we're really getting them than we are on the safety benefits that we can see?
Thank you. I'm deeply honored to be invited to this conference on the heterogeneity of the value of statistical life, whose title I have no idea what it means. Actually, I do know what it means. My wife, who's an econometrician, told me what it meant. She used to be a econometrician, I should say, before she became a dean and a provost and went over to the dark side. Likewise, I was an economist before I went to work for the government for 37 years. But working in the government tends to dull your economics knowledge. You might have noticed this by looking at some of the recent statements of the newly appointed economists over the last few months. Good, that was a joke. That was definitely a joke. It is also very intimidating to be with your prior two bosses on the same panel. So you probably notice I'm going to have to truncate some of the things I say and hold my criticism. But, but Susan Dudley and John Graham are two economists and scientists whose economic IQ has not been affected by their government service. And I guess Kip also, by the way, was technically one of my bosses way back in the Carter administration at the White House Council on Wage and Price Stability. So thank you, Kip, for inviting me and pulling me off a beach in Anguilla, where I spent the last 3 months trying to recover from my 37 years of government service. So to quote a politician who went nowhere after he said this, who am I and why am I here? I mean, what can I add to what Susan and John have said or are going to say? And I guess my comparative advantage is, and I don't think I have an absolute advantage, is my historical perspective. And actually over the years, I've published some articles on the value of statistical life, and in particular the cost per life saved, per statistical life saved, going back to 1975. And I should mention, by the way, that publishing articles in economics journals on this subject while working at the White House is not a great career move. And not only that, but I noticed that my general counsel at OMB, who's still the general counsel at OMB, who's a Nashville native, is here in the audience to monitor what I say. I still have a year to go before I can say anything to anybody in the White House, under SDS rules, by the way, that were predating the existing new rules. So I think I was the first government economist to calculate, publish, and testify a cost per life saved estimate of a government program back in 1975, using also a comparison with willingness to pay estimates. And that was the OSHA coke oven regulation. I was, and I appointed to some data that Thaler and Rosen had in a working paper back then. That was before Kip's data, which Kip, of course, later on showed that their data was all wrong. But the reaction to my testimony at this OSHA hearing back in 1975 resulted in a front-page article in the Washington Post. I was called a refugee from an academic institution. And it would not be the worst name I was called in my government career. But it was true. I was a refugee from an academic institution, one of your rivals, in football anyway, University of Florida, where I was on leave as a Brookings Fellow in Washington. So I'm trying to think about, are things different today? If a government official from the White House testified on the value of life, what I simply did was compare the cost of the regulation to the just the cost of the regulation per the number of lives saved, and you get the implicit value of life based on that. What would happen now? And I'm not sure with the evidence from the senior discount that we've made that much progress, I'm sorry to say. Being ridiculed in the Washington Post about trying to put a value on life gave me some pause, but it didn't stop me from doing it for the next 30 years. And one of the things, to me, it is immoral not to provide such information, the implicit value of life of government actions. And I think it's called transparency, but nevertheless, it's attacked. In 1996, again going to the history, I published a set of about 40 calculations on cost per life saved of regulations that the government had issued or about to issue or decided not to issue, and I stated that. I published that and showed surprise that there was a variance, that government was ineffective in some way, inefficient in some ways. It wasn't cost effective. I simply took all the data from the various agencies, discounted by the same rate for benefits and costs, and used best estimates rather than worst case. And it was kind of a very interesting article. Those numbers, you may know, were widely used over the years to support the need for reform of government interventions and better regulation in particular. Particularly was cited by Professor Viscusi and by Bob Hahn at the AEI. It was also cited by Judge Breyer in his famous book, and importantly enough, it's been cited by Cass Sunstein, the new possible OIRA administrator. But not surprising, other economists, other people, Kip Viscusi, John Graham, Tammy Tangson Graham, others have shown the same thing, that when you compare government interventions with a standard metric and saving lives, you get a huge variance, 2, 3, 4, 5 orders of magnitude. It's very consistent when you do the studies. All the studies are very consistent. So it shows we need to do better. And strangely enough, that finding was attacked. And to make a long story short, in the 90s, in the middle 90s, a group of environmental lawyers at Georgetown Law School got together and decided that they should, a study group, that they should start looking at all this data that economists had done and looking at it very closely. And that resulted in a particular critical critique of my table, it was called, in the Yale Law Review, 100 pages, 500 footnotes. Wow, a lot more than economists could ever put together, which was very critical. And then from there, after attacking me, they went on to attack Kip Viscusi, Bob Hahn, John Graham, and even Cass Sunstein. The person they have not attacked is Judge Stephen Breyer. I don't know why. And he cited and used the same numbers and made the same points that we have all done at this table. So let me say that Kip is clearly ahead of the curve as usual. We economists are clearly at a disadvantage in arguing with lawyers who write better, use more footnotes, as I said, don't have to have their articles peer-reviewed by their colleagues who are out to get them. And they really do write better, too. I mean, they just do. They do write better. Kip decided that what we economists need to do is become lawyers, and to train lawyers and train economists. Economists are trained to be objective. Lawyers are trained to represent their clients. That's obviously a gross generalization. But let's combine the two. And so I think the PhD program in particular here, which is almost unique in the country, should go a long way in trying to bring those two disciplines together to try to improve government decision-making. And I think that's the only way to do it, because right now we're really not talking to each other. I think articles are published in law reviews, articles are published in economics journals, and there are a few like Kip that bridge that gap. A lot of the literature, a lot of the two groups just don't talk to each other. So this is a really important undertaking here you've started, Kip. And as I said, as usual, Kip is way ahead of the rest of the profession. So this influential group of mostly environmental lawyers that have sort of attacked what we're talking about here, trying to shed light on the value of the implicit values of life-saving activities, and also they're attacking the idea that you should have an oversight group in the White House looking across agencies, trying to draw these comparisons among the agencies so you can better allocate resources in the regulatory area as well as the budget area. I mean, that's the innovation here. Everybody agrees you should do it in the budget area, but why not also do it in the regulatory area? Well, that's become controversial. And in fact, you probably know that the executive order under which we have operated since 1981, and in particular since 1993 when President Clinton issued the executive order, is now being reviewed again and is being attacked by various interest groups. It's being defended by others, I guess. I think so that what they proposed is, first of all, rather than using benefit cost analysis to review regulations, but to use pragmatic regulatory impact analysis, where pragmatic means, I guess, what you want it to mean. I mean, that's what I would say. And the other criticism is that you should not, when you review regulations and issue regulations, you should not, you should only use what's permitted, which is required in the statute. You can't use other kinds of activities like the economics if there's any discretion in what can be done. So they're explicitly, and this may be good for you all, I guess, they're explicitly trying to, in OMB's oversight review approach, they're explicitly trying to move it away from hiring economists like me to do the job and to hiring more lawyers like you all to do the job. That is basically what you need to do to try to figure out whether you're fulfilling legislative intent. And if economics isn't mentioned or costs or benefits aren't mentioned, you can't even look at them, even if there's discretion presumably within the regulation to make a decision. So needless to say, unfortunately, Kip, the heterogeneity of value and statistical life to be used in regulatory policymaking is under a bit of a cloud right now. So I think what we have to do is be more, as economists and lawyer economists, to be more advocates of our approach, not to just do the research, but to argue that the value of the research, whatever it may come out to be, is very important and it has to be pursued. But if you can't go ahead with, if we end up losing the benefit cost analysis, but we cannot use willingness to pay to value benefits, there is another approach that I have briefly worked on way back in the 90s and actually worked on it with Kip Viscusi. Back in about in the early 90s, when benefit cost analysis was again under attack, and when in particular reviewing OSHA regulations, you could not use benefit cost analysis because of the Cotton Dust Supreme Court ruling in 1981, we developed at OMB, Randy Lutter and me in particular. I did not have a political boss back then. Jim Blumstein had not been confirmed, so we were kind of a little bit free to do things. We proposed that you use a different kind of cutoff than the willingness to pay, something based on the wealth-health relationship, and we call this health-health analysis, to look at whether there's a direct impact, whether the intended the intention of the regulation was overturned by the unintended consequences. As you know, there's an opportunity cost of any kind of regulatory action. That opportunity cost can be translated into a loss of income and wealth that, through this relationship, this empirical adjusted relationship, could reduce the expenditure on health. And we also found it could affect your risky behavior. Higher income people tend to act in a more risk-averse fashion. And that cutoff could be used as a substitute for benefit cost analysis if benefit cost analysis is said cannot be used. Actually, Cass Sunstein has an article on this, on health analysis, that goes back to this point. So that is a possible fallback position that we could lean on if we have to. So basically, it's an approach that says, that I would like to call first do no harm principle of regulatory review, when harm is defined as the intent of the statute, not by welfare economics. So thus, if BCA can't be used, then I hope you all, when you graduate and perhaps go into academia, like I know somebody wants at least his students with a PhD and law degree to go into, I hope that you will all work together to try to bridge this gap and to try to improve regulatory policy in the next 37 years. And I won't be around to see it, but good luck.
Good afternoon. Dr. Morrall has been very modest about what I think you should understand has been a powerful impact he's had on a 30-year career in the federal government. When I first entered this field as a graduate student, most federal agencies did not even compute how much they were spending to save a life with their different regulations. And those agencies that did so were using a number around $200,000 per life rather than several million dollars per life. The systematic analysis that's now being done at most federal agencies, the European Commission, several European governments, is all rooted in part in the work of John Morrall, Kip Viscusi, and a variety of the academics here. So you shouldn't for a minute think that there hasn't been a major change. The issue that's now really at stake is the question, when agencies save lives with regulations, should you always use the same number to calculate the value of the life saving for those persons? Or should, based upon certain kinds of information, that number be allowed to vary for different populations or different circumstances? As you can imagine, that's a pretty sensitive and politically and ethically sensitive issue, and that is where the literature is at this stage. I want to give you one concrete example of a live regulatory controversy that I was involved in when I was in the government where this issue arose. This was a legislative proposal to Congress from the Bush administration to reduce air pollution from primarily coal-fired power plants. This deliberation occurred in the White House in the 2001-2002 period. And keep in mind, this is a pro-business Republican administration, or at least allegedly, putting forward a multi-billion-dollar tax. I'm sure the utility industry felt it was that way, or proposing to do that. So obviously this is a type of proposal that's difficult to get out of this type of administration. The focus on this discussion right now is on the sulfur and nitrogen pollution from these power plants, though mercury and carbon dioxide were also an important part of the discussion, which we can talk about later if you wish. Questions were as follows. How much should the pollution be reduced from each coal-fired power plant? Should it be 50%, 70%, 90%? Also, should the same percentage reduction apply to the sulfur and nitrogen pollution, or should you allow there to be differences for any reason? Now, the scientists and engineers in rough form told us the following. One, for a given mass emission of these two pollutants, there's more health damage from the sulfur dioxide pollution than the nitrogen dioxide. That's, for example, if you measure the health damage by the number of lives that are lost, or the number of years of life that are lost, or the number of quality-adjusted years of life lost. So in that sense, there's more potential benefit per ton of pollution from going after the sulfur than the nitrogen, but both of them have public health benefits of reducing it. Second of all, the sulfur emissions are easier to control, i.e. less expensive. You can control them more cheaply than the nitrogen because of the nature of the technologies that are needed to put on the stack of the power plant. And as a result, the marginal cost curve on the sulfur pollution control rises more rapidly. On the nitrogen one, rises more rapidly than the sulfur. So to make a long story short, EPA came to us with this set of facts, and they basically persuaded OMB, or at least Dr. Graham, that they had a strong case for a regulation to reduce sulfur control on the order of 90% and nitrogen control on the order of 70%. And they were using at this time a value of statistical life of around $6 million, and Al from EPA is here, and he can correct me if I don't get that number exactly right. The intriguing fact is the other federal agencies were only using numbers around $2 million, and the European Commission, adjusting the euro at the prevailing exchange rate, was around $2 million at that time, and working on a similar regulation of coal-fired power plants. So I went into my boss at the time, Mitch Daniels, currently the governor of Indiana, and I said, Mitch, we have this problem. We have an agreement on the policy, but we have the Department of Energy and several White House offices that we know are not persuaded by this case that I've just described to you. They don't believe EPA's numbers on the science, and they don't believe the numbers on the VSL, and they feel the value of statistical life, they're inflating this number to try to be able to have more environmental regulation. So we had a little dialogue, and basically what the director says, well, how much slop is there in these numbers? I mean, could they be a lot lower, a lot higher? And I said, well, yeah, certainly they could be a lot lower, and they could be a lot higher. And he said, well, do the following. He said, do the most pessimistic calculation for the rule that you can, or the least optimistic from the standpoint, EPA's perspective, see how much you can justify, and then come back. We can talk about this some more. To make a long story short, it turns out you can justify 70% control even if you use $2 million as a value of statistical life. And so he then pushed me into this practice of presenting within the White House agencies, two sets of benefit numbers, one using EPA's standard assumptions, and the other using lower plausible kinds of assumptions, but certainly lower than EPA wanted, and of course the EPA staff were in strong disagreement about using these type of low value of statistical life numbers. The rationale that you could defend for these lower numbers, which is of course the way the Food and Drug Administration have been using these numbers, is that among senior citizens who are predominantly the beneficiaries of this regulation, they have fewer life years remaining and they have fewer quality life years remaining than people in the middle of their lifespan. And the $6 million calculation was based upon losing life in the middle of your lifespan when you have many healthy life years remaining. So that was at least the rationale. So the result ultimately was that we had this dialogue in the White House, and the opponents were actually trying to argue that we shouldn't have any regulation whatsoever. So let me start with the good news. The good news is that the opposition to the proposal dissolved, and then the debate transformed into a debate on whether to do 70% or whether to do 90%. And these kinds of debates are important. There are billions of dollars on the benefit side and on the cost side. The bad news is we only proposed 70% for both pollutants, even though we felt EPA had justified 90% on the sulfur control. But the rationale is interesting. The rationale was we're making a legislative proposal, and we may have to have room to adjust in the Congress as Congress decides what they're going to do. So we could start with 70%, and we could leave open some room on sulfur, if necessary, to go to 80 or 90% if we want to negotiate down the road. However, to make a long story short, the politics of global warming and carbon dioxide were so difficult and connected to this proposal that negotiation ultimately never happened. The other interesting feature about this is the communications people in the White House were very attracted to the idea of the same percentage reduction for each pollutant. They thought that was much easier to explain, and they felt that they were the ones who had the obligation to do that explanation, and they either wanted 90 for both or 70% for both. They didn't want to explain the distinction. Now, the result ultimately was that Congress did not pass legislation in this area, but our creative lawyers asserted that they had found authority in the Clean Air Act to do what we wanted to do anyway. So we issued these regulations with executive power rather than legislative power, and they were litigated over the last couple years, and there are all kinds of warts and legal problems with these regulations, but they are today still in effect, and it looks like they're likely to stay in effect in roughly this form for the foreseeable future. So the question I ask you to think about in conclusion is, what do you think about this idea of a single value for all populations? And I think you need to broaden your perspective to think about children, middle-aged people, and senior citizens. In medicine and in health, it's standard to look at how many years of life are you remaining and what the quality of the life years are. But in economics, they're kind of resisting this idea because they know that when people are senior citizens, they care deeply about their health. They have a lot of risk that they're facing, and their values are more health-oriented at that stage, so they want to give a lot of weight to the impacts on the senior citizens. I think it's a very interesting question, and it's one that's certainly not resolved. That's the senior death discount. Thank you very much.
Okay, well, I'm sure there are many people in the audience who would like to ask questions. I, for one, hadn't realized that pollutants have rights under the Equal Protection Clause. So why don't we open the floor to questions to this wonderfully informative panel. Frank, yeah.
I know the conference is on value of life, but certainly in terms of health benefits, personal health benefits, and environmental health, morbidity and disability are big deals. I mean, most people who have a traffic accident don't die. They may be injured, disabled for a certain short period of time. A lot of people get asthma, they get, and it's not something that is readily translated into qualities because it may be just a transition, just on bad days they get it, once in 3 years or whatever. And those benefits could be quite, high, relative to survival benefits. Why is there so much, I'd say, lack of emphasis? I mean, you mentioned, John, you mentioned qualities very quickly, and qualities don't even capture necessarily all of what we're talking about here. So why is there so little concern about this other piece when it probably is such an important piece, part of the benefit calculation?
I think it's a fabulous question. I'll let others give their perspective on that. There is, if you look at the details of the analysis documents that support EPA regulations and Department of Transportation regulations, they do quantify the number of non-fatal illnesses and injuries. They do have estimates of the monetary value of averting those. But what drives these calculations is the fact that the value of statistical life saved is so high compared to the valuations they're using on the non-fatal impacts, that even though the non-fatal impacts are more frequent, they're overwhelmed by this 6 billion number, for example. Is that valid? I mean, I don't know. I think there are people here who know a lot about that literature more than I do, but I think you're raising a really interesting question.
I'm not clear. One observation is the Department of Transportation actually combines their mortality and their morbidity into one figure. They have an equivalent lives saved figure. So roughly they'll take 6 accidents that don't kill you And that's equivalent to one accident that kills you. And so when Department of Transportation does their estimates, that's how they'll do it. But agencies they do look at non-fatal. For example, lead. There were a couple regulations when I was there aimed at reducing lead, and that's all about children's IQ, and they put values on that.
But how do they get, the science is so much cruder than even the VSLs. Even where we are.
Well, if you're talking about the,
You know, is equal to, I don't think, how you get that number.
if you look at the workplace literature that forms the foundation for the $6 million number on life saved, many of those studies, or at least some of them, also have separate measures of what the wage premium is for a non-fatal injury on the job. And that number will typically be maybe a factor of 100 or 50 or 200 smaller, suggesting that the premium that a worker insists on for losing fingers or whatever is going to be smaller than it is for losing their life. But the magnitude of that, whether that magnitude is the right ratio, I think that's the key question. And there are people here who study this problem.
Well, that's right. I was thinking Kip and
I'd be
Joni are
interested to
some
know
of
how
the
confident they are that
key
they've got
researchers.
that relative valuation, right? Because remember, the non-fatal impacts are going to be hundreds and thousands of times more frequent. So if you get the valuation wrong, you're in trouble.
Yes.
Can I just note that, I'm sorry, if you look at EPA's estimates of the IQ effects of lead, you can deduce that the current generation of students is about 20 IQ points smarter than the previous generation. I don't know if the professors would agree, but.
Yes.
Actually, I have a governance question, I guess, from your wealth of experience. John had talked about kind of the legal way of budget problems and the economist way. For the most part, I think the way the agencies are set up, it's very much the legal way. EPA advocates for the environment, education advocates for education, DOE, they love energy subsidies, and go on down the line. And within an organization, there's not a weighing of benefits and costs. And presumably that's probably OIR's biggest job, is to kind of be the honest broker there and kind of mention cost, but yet it's still external to the agency, hence all the tensions and kind of gamesmanship, I think, that takes place between agencies and OIR and all the rest. I guess I'm wondering, it's a big picture question, the answer may be no, but is there like a different model that you can envision that makes the decision making, instead of, again, like having a lawyer advocating for the environment, getting one agency to kind of consider both sides kind of more thoroughly, so that there is a way of the costs and benefits up front. And maybe the model we have now is the best you can do it. And just as an example, when Congress is deliberating on something and they leave something for CBO to analyze it, as they're doing now with all the bill, CBO is the benefit and cost analysis. So they're doing both sides within the same organization, and there's not as much kind of infighting, or I don't know if infighting is the right word, it's not the same kind of tension, I guess. So I'm wondering if there's something to be learned from that, or if there's just in your experience in OIRA, and it works well, that having kind of this separate organization to check to make sure that the costs are being considered also, or whether or not there's a different way to do it.
Just a quick response to remind people that the Congressional Budget Office is a policy analysis agency. The Office of Management and Budget has both analytic responsibilities and a policy-making responsibility. As a consequence, the analogy is not fully drawn. One other point is that there is a growing development in the regulatory agencies of little offices that have economists and policy analysts. We have Al McGartland here from EPA, who's played over the last 20 years a very important role in trying to promote the role of economic analysis in the Environmental Protection Agency, for example. It's interesting that in the European Commission, there have been efforts over the years to build it into the various commissions, the DGs, the Director General offices. But they have recently, within the last 18 months, concluded that that's not sufficient. And they have created a centralized unit in the Secretary General's office, not unlike OMB or OIRA, that reviews these types of activities. So I think inevitably when you push hard on it, you realize you can't rely completely on even a well-functioning regulatory agency to get these things exactly right. You need some oversight of that process.
Just as a follow-up, does anyone have any comment about the regulatory budget proposals that were floated, which I understand were designed to achieve exactly the purpose that the question asks?
Yeah, do you want to?
Yeah, I was actually going to answer that, say by another model that actually Susan and I worked on way back. She was actually a staff member of OMB way back in the 80s, that she worked on and I worked on later and actually discussed with the OECD in Europe, is the regulatory budget model, where you can, the idea is that it's the budget, the fiscal budget and the regulatory budget are exactly analogous. The same public resources are being used and allocated for public purposes. So why not use a budgetary mechanism in the regulatory area? In other words, the legislature or OMB in the legislature could set targets among the different agencies and allow them to cost effectively, we hope, set their own regulatory priorities and establish them. This was recently attempted in the UK in a parliamentary system where they actually went forward to propose this. And we worked with them a little bit. They came over and briefed us. They moved it forward. But my understanding is, and John may know more about this than I, that they decided there was too much opposition from the individual agencies in the UK, so they dropped that proposal. But nevertheless, if we do have to move away from benefit cost analysis because it's so controversial, then I think it is one approach combined with John's cost-effectiveness analysis that he discussed about and the qualities that we mentioned, quality-adjusted life years as a metric. This may be an approach of the future. I mean, after all, OMB at one time did look at benefits and costs for individual proposals, but eventually it ended up that we moved more and more in the fiscal side to be a cost-effectiveness kind of allocator of resources.
Yes.
Is there a role for medical costs in these cost-benefit analyses? It strikes me that the DSLs are calculated based on willingness to pay or based on wages, but if in fact medical technology is quite successful in reducing fatalities, turning them into morbidity cases, the really big cost may be the enormous amount we spent there, and that could have been used in other medical areas and saved even more lives, and they should be tacked on and added on to the ones that are used directly in the calculation.
Just briefly on that, the medical costs are looked at, but if you believe that the willingness to pay estimates for the intrinsic value of reducing disease or mortality are in the right ballpark, it turns out, counterintuitively, the medical costs are small relative to these other numbers.
Yes.
I want to ask kind of a big picture question about what do you think is either the justification for benefit cost analysis? What is it trying to do? Let me give you two possible answers. One is it's to answer the Kelder-Hicks compensation test. Do the people who gain from a regulation gain enough that they could compensate the people who are harmed? Or is it an approximation of a utilitarian calculation where we're just trying to add up social utility because we don't know how to measure utility exact between people? We're assuming $1 gives the same marginal utility to each person. And this has implications, I think, for what we would do with our information about heterogeneity of HVSL and other methods.
I got lots of opinions, but why don't you guys take a crack? No?
This brings me back to something that I didn't say in my formal remarks, and that is that benefit cost analysis is an essential tool for understanding regulations, but it should not be the first step, and it should not be the only tool. That first, because we need first to understand what the problem is we're trying to address, and whether regulation is the right way to address that problem, because it is. We are never going to be able to calculate and analyze and figure out what's going to make everybody better off, what's going to improve utility for individuals who, so to the extent we can allow decisions to be made by individuals, we should do that first. And regulation we should only have to do benefit cost analysis if we know we've got a decision that cannot be a private decision that must be made as a public decision, which I guess leads me to, I guess it's more of the former of your two, the Calder-Hicks, rather than trying to figure out different people's utility and trade off things so that we can improve one person's utility with them.
As a practical matter, the Cal or Hickson one is the only one that's operational. So for the government to directly implement the other one, I don't think is feasible. But at a philosophical level, I think probably the other one has better grounding. That what we really want to do is we want to increase the well-being of the society overall. And we're using willingness to pay as a surrogate for it, because we don't really know exactly how to do the well-being measurement in a way that's interpersonally comparable and all those features. So I think we're sort of doing what we can at a practical level. And the good news is, in a substantial fraction of these rules, it probably wouldn't matter which of the two you did. But there are going to be some, and you put your finger on some where I think it probably does matter.
Let's see. Yes, please.
I want to speak to another benefit cost analysis hasn't been put on the table. If you go back to a period prior to 1981, when the first executive order was issued, and the only situation that I know anything about is the case of EPA, oftentimes the rulemaking process within the agency was established in such a way that different groups, well-intentioned, charged with responsibilities under the rulemaking process, came to the table to decide on rules, and the analysis didn't fit together. That is, the risk folks would be working on one thing, the cost folks would be working on another thing, the atmospheric folks would be working on another thing, and there wasn't necessarily a clear template that linked it all together. Now, even though benefit cost analysis could not be used in the rulemaking process for most of EPA's regulations, it forced an internal transparency because they had to convert major rules into benefits and costs. And prior to that, they didn't have to do that. And I don't know whether that's true in other agencies, but it transformed the communication within the agency. So one way of thinking about alternatives to benefit cost analysis is they would also transform that nature of that communication. And are we going to be happy about the way that transformation takes place?
Just quickly, I think that you're presuming that the communication is net good. I think you're probably right. But let's at least be candid about the fact that there are people who have written that there are different ways to get decisions made that aren't necessarily orderly and that sort of thing. But I tend to agree with you that one other, I think, additional point to make is that when you get to the research side, of getting more information to improve our understanding of these various features, that communication is very valuable because you get a sense of which people are uncertain by a factor of 5 and which people are uncertain by a factor of 100 and 1,000, and you get that you don't get into that dialogue unless you have a framework like cost benefit where you can sort of see all the pieces come together and resolve.
Let's see, I think we have time for just one more question. Yes.
I'm guessing it's the politics, but I'm wondering why in more cases the risk calculation isn't used kind of as a waypoint to get toward CEA. Let me give you an example. I've done this calculation for mine safety. These are cost and effective regs. Either those are terrible accidents. You can go and look at your paper 10 and 10 and find the same kind of people, middle-aged men, and find a whole bunch of regs like defibrillators that will save more lives per dollar.
I'm assuming it's